Hi, everyone. Thank you for joining us for our session with the Data Protection Foundation's reviews. This week we have Advocate Manenji and Justice Anthony who will be presenting Chapter 5 for us. Last week we covered core data protection principles, and this week they are covering a legal basis for processing of personal data. I believe Justice said he would be first. I'm not sure. Can I get a confirmation who will be first?
Yes, I
Okay.
think I would.
So Justice will be doing the presentation first on legal basis for processing of personal data and followed by Advocate Manenji. And with that, Justice, please take it away. Thank you.
Thank you, Prince. I should say good evening or greetings to all, depending on where you are. It's already 4 p.m. Where I am right now. Um, Today we are talking about the chapter 5. We are looking at chapter 5, the legal basis for processing personal data. So we'll go straight into it because we don't want to waste time. The book, The Foundation of Data Protections, is talking about the legal basis for processing personal data based upon the GDPR, and then it's looking at the six legal basis that the GDPR established, and then the rest of the jurisdiction, their limitations, and when to use them or where not to use them. We all know the book structure already. It has an overview. It has a learning objective, the overview, and then the context, each of them. So I'm not going to go into all those things. We'll jump into the topic itself. So this chapter 4 is actually talking about the legal basis, what justification an organization or a controller has to process data. There must be a legal justification when you choose to process a personal data or you want to use personal data for some processing. What do you have as a legal basis or to back up your processing? So in terms of GDPR has six legal bases. They are not in order. Anyone can be first or not, but they are not per se in order. You have the consent, you have contract, you have legal obligation, you have vital interests, you have public tax, and then you have legitimate interests. These are the six legal bases upon which a processing can be lawful. You recall that we say in chapter 4 that the processing has to be lawful. So you need one of those bases. It can be the consent, it can be the contract, it can be the vital interest, or so on. These bases are defined in the Article 6(1), Article 6, Paragraph 1 of the GDPR, where they list all the six. I think it will be fair to read them out over here. So the Article 6 define consent as consent. The data subject has given consent to the processing of one or more specific purposes. Contract processing is necessary for the performance of a contract to which the data subject is party or to take steps at the request of the data subject prior to entering into a contract. Legal obligations processing is necessary for compliance with a legal obligation to which the controller is subject. Vital interest processing is necessary to protect the vital interest of the data subject or another natural person. Public tax processing is necessary for the performance of a task carried out in the public interest or in the exercise of official authority vested in the controller. Then you have the legitimate interest. Processing is necessary for the purpose of legitimate interest pursued by the controller or by a third party, except where such interests are overridden by the interest of fundamental rights and freedoms of the data subject. These are the 6 legal bases based on which processing personal data can be lawfully or justified as using it. Yes, even after this, we all know that there are some special categories of data. So you can use any of these, but for the special categories of data, Article 9 have some additional guideline to add to what we have, but that will be handled somewhere around the line by Allan. Now, let's look at them one by one. Legal basis 1 is consent. We all know that consent is probably the most popular one among all the 6. Everybody talks about consent, but some of the terms is not well understood or we misapplied it. GDPR has a strict rule or requirement for valid consent, and organization has to know or understand when they want to use consent to be able to not fall victims of the law. They have to understand and apply it correctly. When you look at the definition of the consent from the perspective of GDPR, we said what? Consent is a freely given, specific, informed, and unambiguous indication of the data subject wishes by which he or she, by a statement or a clear affirmative action, signify agreement to the processing of personal data relating to him or her. So we see that there are some terms or some elements that are required to make the consent valid. Consent has to be freely given. It's not something that is coerced. It's not something that is forced on the person. It has to be a choice. So consent must be freely given, meaning that the individual has a genuine choice and control. The person is not forced to or is not coerced to accept the terms of the processing. And to that effect, there are some factors that a controller or the organization has to look for or have to verify to make sure that they apply consent the right way. The first one is imbalanced power. When we talk about imbalanced power, it means that there is no pressure from anywhere that to make the individual accept unwillingly they consent. DDPA state that the consent is unlikely to be freely given in the context of employment, for instance. I'm working with you and you ask me to do something, definitely it will be difficult for me. So there is power imbalance over there. Employee may feel unable to refuse their employer's request. So that consent, some of the time is not because there is power imbalance. Or in the case of children, for instance, if they didn't understand or they don't know what the consent means, so the children also may feel like they didn't understand, they just consent to it. Is one of the other aspects of power imbalance that DDPR is looking at. The second element or factor that determine the consent is what? Conditional service. If consent is a condition of accessing a service and the processing is not necessary for providing the service, consent is not freely given. Example is given of a social media platform whereby before you use the social media, they want you to consent to a behavioral advertising, which actually is not the purpose of the service they are providing or what you are using they are using the consent for. So definitely that is not a freely given consent. So we have power imbalance, we have conditional service. The next one is bundle consent. There are times whereby you find a number of purposes, processing purposes, bundled together under one consent. So the data subject doesn't have the ability to choose one particular purpose or not to say, oh, I don't not no to one purpose. So GDPR is saying consent must be granular. Each processing purpose, bundle consent also is not a freely given consent. The fourth element is there is no real choice over there. Realistically, there is no choice. There is no alternative to the consenting. Or if refusing consent will result in a significant detriment, consent is not freely given. Those are the four elements that play in a freely given consent, if the consent has to be freely given. The next element or the next aspect is specific. For consent to be valid, consent has to be specific to a particular purpose. So you can't just give a blanket consent or ask for a blanket consent for all the purposes and say it is a consent. It's not a valid consent. So organization must endeavor to identify specific purposes and obtain separate consent for each purpose. An example, for instance, if organization might obtain consent for sending a marketing email, separate consent for sharing data subjects, the data with partners or different person, and they need what consent for using the data for research. So those three, for instance, cannot be one consent, but each one has its own specific consent. The data subject should consent to each of them. The other aspect of being specific is what? You don't put a blank statement. We may use your data for business purposes. What are they? you need to list them out, and the person need to consent to each and every one of those purposes. If not, it's not a valid consent. The third aspect is being informed. Consent have to be a clear and something that is concise for the person to understand, or the data subject, meaning that the individual understand what they are consenting to. If the individual cannot comprehend or understand what he is consenting to, then it is not a valid consent. In this case also, informed, the controller must provide enough information to the data subject. For instance, the identity of the controller, the purpose of the processing, the type of data, the categories of data they are collecting, the right to withdraw, and the information about automated decision also is something that need to be well documented or in the consent form. Consent has to also be in a plain language. And mostly in this part of the world, there may be a need for somebody to explain the terms of the consent in our local languages to the people who cannot read English or French or any of the languages. So they need to inform the person. The person's decision should be well informed before the consent is given. If not, the consent is not freely given. Then the third aspect of a valid consent is that the consent must not be ambiguous, meaning that there must be no doubt that the individual intends to consent. If you can't justify that actually I am the one who is consenting to the processing, then it's not a valid consent. This requires a clear affirmative action, a statement or conduct that clearly indicates the agreement. So you can't come to me with the consent form already pre-ticked. A box that is already selected is not a valid consent. So that's the fourth point that make a consent valid. Consent must be withdrawable. If the consent that the data subject gave for the processing of the data, he cannot withdraw it, then the consent is not a valid consent. So as simple as the person gave his consent, he should be able to withdraw that consent also easily. But if there are conditions for the withdrawal, or they make the withdrawal impossible or not practicable or burdensome, then that consent is not valid. So those are the four things that the data controller need to consider when he's using consent as a legal basis for processing. But not only that, the data processor or the organization should be able to demonstrate that he or she has a valid consent. That's where the ROPA comes in. The record of processing activity comes in. You, as an organization, you should be able to demonstrate that you have a consent for this processing. You should be able to demonstrate that at this period, the person has withdrawn the consent and it is stopped. You will stop the processing. So if you don't do that, then definitely you have a problem with the regulators. Now, when can you use consent? in the book, it's specified there clearly that when there is a genuine choice, the choice is there about whether processing occurs. Or when processing is not necessary for providing a service or fulfilling a contract. When the organization can meet all the requirements of valid consent. When we talk about valid consent, we talk about the freely given, the specificity, the informed, and then the unambiguity. Then what? Add to that, the withdrawal of the consent. If you can justify that you have that, then you can use consent. Consent is appropriate for marketing communication, for sharing data with third party. When you are processing, you collect data and you need to share it with somebody, you definitely need to seek consent, and people, the data subjects can say, yes, I agree, you can send my data to social person or not, just use it for you yourself, don't send it. When you are using cookies or tracking, you can use consent also. Most of the website has that, some don't have it, but any website that is using cookies should be able to demonstrate that consent is received for all the information they are collecting. However, consent is not appropriate in many situations. It should not be used when there is power imbalance. That we spoke about it earlier. When there is power imbalance, it is not good to use consent. The person can turn back and say, because of the power imbalance, I didn't want to consent, but I've consented. So you have a problem with the regulators. Or when the processing is necessary for a service, it's better you use contract than that. Or when the withdrawal is almost non-existing, then don't use consent. There are some common mistakes also that are made most of the time with consent, is especially using a pre-tick box or bundling consent for multiple purposes, making consent a conditions of service when processing is not necessary for the service. Failing to provide clear information about what is being consented also is a mistake some of the data controllers make some of the time. So those are the things that you need to look at when you want to use consent. Consent is most popular, but is some of the time misunderstood. So people should be careful when using consent. The second legal basis is contract. The definition here is processing is lawful if it is necessary for the performance of a contract to which the individual is party, or to take a step at the request of the individual prior to entering into a contract. This legal basis is mostly used in the business environment where there is a need to provide a service to a customer. One of the basis of contract is that the necessity for a performance of contract. There should be a necessity, or it should be necessary, objectively necessary to fulfill the contract. If the processing is not necessary to fulfill the contract, then there is no need for a contract. This means that the contract will not be performed without the processing of the data. So if you are using a contract, be sure that definitely the processing you are going to do is to perform the contract. Other than that, it's better you look for another legal basis to process your data. If you consider the example of a retail processing, for instance, the retailer cannot deliver the product to the subject or to the buyer without processing the data, the buyer's address. So definitely you see that that is actually a contractual something that I need to process your contact so that your address or contact address so that I can send you the product you want. And definitely I need the information, your payment information, so that I can collect my money. So that justifies the contract, and you can use that for the processing. But you can't use a customer's purchasing history to send a personalized marketing materials to the person or to the customer based upon that contract. No, it's not performing a contract. You are not performing the contract. When you do that, you are violating the person. So you need a consent, or you need another legal basis for such marketing activity. Now, what constitutes a contract? We all know most of the time a contract is just a formal written agreement or a formal written document, but it can also be a terms of service or terms and condition, or any other agreement that the two parties, the organization and the individual, agreed upon. That's a contract, is a binding contract. Organization cannot simply include any processing that they want in the contract and claim that it is necessary. That's one of the things we have to be very careful when we are establishing or we are using a contract as a legal basis for processing. But the processing must be objectively necessary for the core service or product that the individual is contracting for. And if you don't do that, you will always fall a victim to the regulators, because when attempts to audit or regulators come to audit you and they find out that you have add up or you have add unnecessary things to your contracts that are not supposed to be, just because you want to process somebody's data, you fall victim. So, like for example, when you include a term in a social media platform, terms of service that user data will be used for behavioral advertising, does not make the processing necessary and contractual. So that can be picked up by the controller or the regulator. So you have to be, when you are putting up the contract, you need always to be informed or let the contract be just for what will make the processing. The processing should be just for what to make the contract valid or run the contract. If it's not, if it deviated from it, then definitely it is not the right thing. The next one is the pre-contractual steps. That is also a valid contract. Assuming somebody wants to buy something, or for instance, somebody wants a quote, insurance quote, you definitely need some of that person information. You definitely need to process information about the person, the name, and what insurance the person is buying. Is it health? Is it fire? Is it motor insurance, or all these things? You need that to give a quote. So it's pre-contractual steps that they use. It doesn't mean that you have a signed contract, but you are going to. So you can use that also as a contractual, excuse me, you can use it in a contract. But contract also has limitations. It's not everything that can be in the contract. The first is it can only be used when there is an actual contract or pre-contractual relationship with the individual. The organization has a contract or a pre-contractual relationship with the individual. Secondly, the individual cannot object to processing based on the contract. That's the second limitation. You can't just wake up, because contracts are somewhat a document that is binding. So today I say, okay, I sign a contract for this insurance or this, and then I don't want it, or stop processing my data for that. Based upon this contract, there must be a way or something to follow to. So definitely, you cannot just object to processing. So that individual right to object, cannot be used when contract is in place. Thirdly, the contract legal basis cannot be used as a way to avoid obtaining consent. There are some processing that you know that you have to obtain consent. You can't just use a contract for that. If processing is not truly necessary for the contract, consent or another legal basis must be used. So when do we use contracts? The contract legal basis is appropriate when processing is objectively necessary to fulfill a contract with the individual, or when the individual has requested a pre-contractual steps that require the processing, and when there is a direct contractual relationship with the individual. So those three factors determine the term or when you can use contract to process data. Legal basis number 3 is the legal obligation. Processing is lawful if it is necessary for compliance with a legal obligation to which the controller is subject. This legal basis applies when the law requires the organization to process personal data. So legal obligation means what? The law wants the data controller to process a certain type of data or something. So legal obligation must be established in terms of GDPR or EU. The law has to establish the legal obligation. The legal obligation is established in the law or the law of the member states, the EU. But assuming there is a law let's say Nigeria or Ghana or any other country, that law cannot be used as a legal obligation, excuse me, for processing EU data. No, it cannot, it's not valid. So it has to be under GDPR, the law must be established in EU, within the EU member state, or by the EU, the Commission itself. That can be used to process or to say it's a legal obligation. And when we consider the EU space, most legal obligation is what? The accounting law require, for instance, a retention of financial records or doing due diligence to avoid money laundering. The anti-money laundering law also require customer due diligence. Employment law requires personal record to be retained. Health and safety law also requires workspace incidents, for instance, information. And the court also can order or a legal proceeding that requires disclosure of information. Those are things that are established in the law. So legal obligation should be well established in the law, defined by the law, and the data controller must identify that obligation or what made it necessary for the data controller to process the data. Organizations should be able to identify the specific legal provision that created the obligation. So if you want, you always, or how do I say it? The data controllers need to understand or identify the provision of the law that require them to process the data. But when you don't know it or you don't have it, then you can use a vague legal requirement or to say, oh, because this is to satisfy a legal requirement that you are processing or you want to process this type of data. It will not work. You need to identify the provision that creates the obligation. Legal obligation also has some limitation. It's quite narrow, and it's a clear legal requirement to process that data. But if there is no legal requirement to process that data, then you need to look for another legal basis to process that data. But it's very narrow. It's only within the definition of the law. When can we use legal obligation? That's what it's already said. Or you can use it when it is established in the law, when the law requires that you should process that data. Mostly in EU, the tax law requires some record keeping, even for employment and so on. Even in our own jurisdiction also, it happens. Most of the legal obligations within our countries also has that the law has established them and it must be applied. So, number 4 is the vital interest legal basis. It says processing is lawful if it is necessary to protect the vital interest of the individual or another personal, natural person. Vital interest refer to life or death situation or situation involving serious harm to physical or mental health. So this is the definition of the vital interest. It requires life or death situations. Most examples are what? Medical emergency, where the person, the individual cannot, at the point where the processing is needed, cannot give a consent for the processing. Or for instance, in an emergency situation whereby somebody is missing, they need to process information and locate a person. Or somebody is in danger, imminent danger or imminent harm. So those are vital interests that need processing and it must be applied. The key is that the situation must involve vital interest, fundamental interest related to life, health, or physical integrity. Processing to protect financial interest, reputational interest, or another vital interest does not qualify as a vital interest legal basis, or you can use that. If it's for financial, you can wait. If it's reputational interest, you can use it. It's a vital interest, but it cannot be. You can use it to process data. It has to be necessary and no other means to use a vital interest. The processing must be necessary to protect the vital interest, and there must be no other reasonable means to protect those interests. If there is no other reasonable means to protect those interests, you can use a vital interest. Vital interest also has limitations. It's also narrow, but most of the time it's used in the hospital, processing patient data to provide routine medical care would not typically rely on consent. A hospital processing patient's data to provide routine medical care will typically rely on consent or contract or legal obligation, not vital interest. This is how narrow it is. So if I go to the hospital, the doctor cannot say for routine checks, you use a vital interest. It's not possible. He can use consent or legal obligation, but you can't use a vital interest for that. When to use vital interest is said in an emergency situation where the risk to the life of the individual or a serious harm to the individual and there is no other means to obtain consent, then you can use vital interest. So it's saying vital interest legal basis is appropriate when there is an emergency situation involving risk to life or serious harm. When processing is necessary to protect the vital interest, when obtaining consent is not possible, or when there is no other reasonable means to protect the vital interest of the person. The next legal basis is public tax. Processing is lawful if it is necessary for the performance of a task carried out in the public interest or in the exercise of official authority vested in the controller. This legal basis is primarily relevant for public authority and organizations performing public functions. So public tax also, most of the time, we can also say it's defined within the law, and whatever function is performed is to the interest of the public. It can include public health monitoring and disaster surveillance, for instance. It's a public tax. Educational activities by public school or universities, law enforcement and criminal justice activities, regulatory oversight and enforcement. Those can be considered as a public or a tax in the public interest. The tax must be established in law, especially within the EU, when we consider the GDPR, EU law or member state law, or equivalent in other jurisdictions. Organizations cannot simply declare that their activities are in the public interest. There must be a legal basis for the public tax. Official authorities also. Processing is the exercise of official authorities. Refer to activities where the organization has been vested with public power. For instance, government agencies, regulatory bodies, public authority can also apply, and it can also apply to private organization that has been delegated with official authority by the law. So when we look at, for instance, the data protection regulatory authorities, for instance, they are performing an official, or they are carrying out their official authority. So their job is vested in the law, and they are doing what is supposed to be, or the law asks them to do. They enforce the law, like a tax collection, for instance, law enforcement agencies, the police, the criminal investigation, all those things are doing what is in the public interest, public tax or official authorities. So it's something that is given to them or establishing the law. As with the other legal basis, processing must be necessary for the public tax or exercise of official authorities. It has to be. If it's not, you don't do it. Yes, there is limitation to that. The public tax legal basis is generally not available to private sectors organizations unless they have been specifically delegated a public function by law. So normally this is reserved to the public or let's say organizations that are not in the private sector unless they have been delegated by law. Additionally, even public authorities cannot use public tax legal basis for all their processing. They can only do that within the limit or the confines of the law. They can't go beyond. So processing their human resource purpose, for instance, cannot be a legal basis for them. They can't use public tax to process for human resource processing. No, they can't use it. The last but not the least, that's number 6, is legitimate interest. Processing is lawful if it is necessary for the purpose of the legitimate interest pursued by the controller or a third party, except where such interests are overridden by the interest of fundamental right and freedom of the individual. This is the most flexible legal basis, but also the most complex to apply. When it comes to legitimate interest, it's flexible, but it's also just like consent is a bit dicey, or is dicey, we should say. You have at least 3 tests to perform when to use legal basis. To use legitimate interest as a legal basis. A legitimate interest is an interest that is lawful, clearly articulated, and real and present, not speculative. Legitimate interest can be commercial interests such as fraud prevention, network security, direct marketing to existing customers. Organizational interests such as employee administration or corporate restructuring, or broader interests such as journalism, academic expression, or public debate can also be classified as a legitimate interest. However, an interest is not legitimate if it involves unlawful activity, is contrary to public policy, or violates fundamental rights. Organization must be able to clearly articulate the specific legitimate interests being pursued. The second test is it necessary? The necessity. Processing must be necessary to achieve the legitimate interest. This means that the interest could not reasonably be achieved without the processing, or that the processing is the least intrusive means to achieve the interest. Necessity requires considering whether there are less intrusive alternatives. For example, if the interest can be achieved using anonymized data instead of personal data, then processing personal data is not necessary. The third test is the balancing test. Even if there is a legitimate interest and processing is necessary, that's the two. We establish that there is a legitimate interest and the processing is necessary. The third balancing is saying that the legitimate interest must not be overridden by the interest. No. The balancing test say that legitimate interest should not override the interest, rights, or freedom of the individual. So we need the organization or the controller need to balance the organizations need to weigh the legitimate interest against the rights of the individual or the interests of the individual. Factors to consider in balancing tests include the nature of the data, how sensitive is the data, and if it's the sensitivity of the data outweigh or are heavily in favor of the individual, the reasonable expectation of the individual, with unexpected processing weighing in favor of the individual. The potential impact of the on the individual also need to be considered. The relationship between the organization and the individual. So you need to consider, or the data controller need to consider all these balancing tests. But aside that, the organization needs to also conduct a legitimate interest assessment to determine if using the legitimate interest would not be detrimental to the individual. And the legitimate interest assessment should be also must be documented to demonstrate compliance when they are using, when it's being used. But the right to object, unlike most of the legal bases, individuals have the right to object to processing based on legitimate interest. When an individual objects, the organization must stop the processing. So individual can also object to the processing of their data based upon the legitimate interest. Legitimate interest cannot be used by public authorities. They cannot use legitimate interest. I think this is where I will stop and I will ask Allan to continue.
Uh, you can come on, Allan. We're waiting for you. It's your mic is off.
Hi, Prince. So I really don't know where to kind of say. It's all straight through the background. I kind of also had prepared what Justice is just going to say, but I understand that he mainly discussed the issues of consent when he went to look in his review. So I hope for the purpose of the audience, they'll understand that there might be repetition as we had not aligned before with justice before we did a presentation. So I'm just going to go into what I'd prepared about the review. So obviously I'll skip ease of consent because obviously we had he has discussed them in detail, and then I'll look into the other issues that came up in the book as we were reviewing the book. So obviously for me, when I saw that Amaka in chapter number 5, she heavily borrowed from the GDPR, and when she talks about the lawful basis of processing personal information, and which doesn't go to look at other jurisdictions. For example, in Zimbabwe, we have 8 legal bases, and the GDPR, they only have 6. So maybe I'm going to start by looking at the issue of contractual obligation, where processing is necessary for the performance of a contract. And in the book, under this legal basis, what it essentially means, or what she describes in the book, is that sometimes you may process data without the consent, or process personal information without the consent of the subject, if it is necessary to perform, if it is necessary in performance of a contract to which a data subject is subject to. What it means is that a data controller and the data subject may have a contract, and in terms of that contract, there are certain obligations that the data controller will need to perform with personal information for him to be able, or her to be able, to discharge their obligations under that contract. So obviously, when you read the book, what is very important is that there must be a contract first to talk about, and in that contract, that clear obligation must stem out. For example, when someone buys goods online, you buy some shoes online, and obviously you want those to be delivered to your house address. So your house address being personal information may be used, even if you don't give consent to the by the or but the online shop to give it to the courier company to deliver the goods to your house. So clearly from this example, you notice that there is indeed a contract between the two parties, and personal information is being used for the purpose of the contract, which means that organizations, data controllers, as we may put them, they may not use the information for any other purposes other than that which is being stated in the contract, what stands first terms of the contract. And in the book, she also covers the pre-contractual steps that are supposed to be taken by individuals as they may rely on this. For example, if processing is if you're going to process payment details to complete an online purchase, or processing information to provide a quotation. So obviously these are some of the pre-contractual steps that may be done. And as I already had explained, there are limitations that are found under this basis. For example, it cannot be used for processing of unrelated of unrelated activities not related to the contract. And usually for marketing purposes, this would require another legal basis. Um, so the key aspect is that the processing must be necessary for the open contract to be fulfilled, not out of convenience. I think you see that when you get to read the book. And then I'll move on to another. So I'm just trying now to just to summarize the other ones that come out. So we'll talk also about the legal obligations, whereby processing is done by the tax controllers, where it is required to comply with the law. Just a second. So I was saying, so processing is necessary, is lawful if it's done to comply with certain laws of a country. It will be laws, acts of parliament, also maybe court orders, for example, whereby the court will require the organization to use personal information for it to be compliant. So examples, obviously, the ones that you know, we talk about tax reporting obligations. Um, talk about tax reporting obligations, whereby we all know that personal information will be processed for the purpose of us being able to pay tax, and then also the anti-money laundering regulations. I'll give an example from Zimbabwe, where I am from, whereby if you have a suspicious transaction in a bank account, the bank is supposed to, in terms of the anti-money laundering laws, to flag your account and notify the financial intelligence unit. So obviously they may not need to seek your consent for that to okay, but they will obviously do so. They will obviously do so without us seeking your consent. So I was just checking because I want to see my notes where they take me to special categories of data. So when we are talking about special categories of data, usually we are referring. So I've just switched off to what I was saying, because as you may have noticed, I was dropping from the meeting, so I might have been repeating what had been covered already. So I'm just supposed to just to wanting to cover on the issues of special categories of data, and then we'll move on like that. So obviously, special categories of data refer to highly sensitive personal information that requires enhanced protection because its misuse can lead to discrimination, stigma, or harm to individuals. For example, if you read Article 9 of the GDPR, processing of that data is generally prohibited unless specific conditions they are met. Maybe what we can do before we talk about those conditions, I can quickly discuss what are some of the special categories of data. So, in other jurisdictions, maybe it's important to flag this out, that special categories of data will also may also be referred to as native data. So, interestingly to note that our own law, because sorry, I'll be giving more examples from Zimbabwe because that's where I am from. In our own Zimbabwean context, our act then talks about sensitive data, and then it goes on to have another branch or a category under what they call special categories of data. So these are and some of them, they are not limited to that, is racial or ethnic origin, political opinions, religious or philosophical beliefs, studio membership, genetic data, health data, and data that is containing someone's sex life or sexual orientation. This is mainly in terms of Article 9. So the reason why, like I'd explained, the reason why these special categories may need extra protection is because obviously is of discrimination, social stigma, political persecution, and I'm sure that is very rampant in Africa about political persecution that members of the same political party may be persecuted if they if their political parties are exposed. So when you're processing special categories of data, then you have to go in. These are some of the questions that are supposed to be met. The first example is that there needs to be explicit consent that comes for the data subject, depending with the jurisdiction. Other jurisdictions will say when they say explicit consent, what they actually mean is that there is need to have written consent from a data subject that this type of information is being are processed. And basically, I think issues of awareness that the subject themselves must appreciate that the type of data that's being used or processed is very sensitive data. And again, it also talks about issues of if in the special categories of data include issues of like employment or social security law, whereby there is no there is imbalance of power between the controller and the data subject, then other legal basis must be relied upon where we may necessarily rely on consent because like what was explained before, consent then doesn't really become necessary under that type of processing of personal data. And she then also then goes on to explain um, that there are additional safeguards that will be required under that processing of data, where they should be strict access controls and issues of encryption and data minimization.
Your mic is disabled.
Okay. I'm sorry. I think I should be having a very bad connection. But I think should be able to continue. I've been booted out.
It's okay.
All right. Let me just say. So as I was explaining earlier on to say that so whenever you're talking about processing of special categories of data, there is need for there to be there is need um to be additional safeguards that are required. And then we're talking about strict access controls, the encryption of the security measures. And then we go back to the other earlier chapters where we talk about the principles where they're supposed to, where they're. All right, but we were then after that we were then supposed to look at the jurisdiction the variations as per the other jurisdictions whereby she then discusses the South African pop here whereby it has got legal bases that are very similar to that of the GDPR and then how China's law introduces consent, contract performance, statutory duties. So, in other words, these are South Africa and China have got similar that of GDPR, and maybe what will be very different, maybe the issues of semantics. But what is interesting is to note issues about the Japan, so about the Brazil the Brazilian law, which is 10 legal bases, but the 10 legal bases that Brazil has can be summarized or can be consumed into six because Brazil also then went a step ahead to then provide legal basis specifically for um, other processing activities such as public health, public policies, and judicial administrative uh, processing, which all of those might simply be under legal obligation. And then obviously, so that will be the wrap up. I noted looked at the conclusion of chapter 5 in the checklist or the pitfalls and practical steps because I would believe that we were simply just supposed to discuss the key highlights of the chapter. So that would be my conclusion. I sincerely apologize for the cuts and the short presentation. That would be all from me, Prince.
Okay. Uh, Thank you, Advocate Manenji. I'm just going to pin myself. Right. Thank you, Advocate Manenji, for that. It's unfortunate, like as you said, the network has been bad. But what we'll take all that in stride, and I guess we can always learn from such issues. Well, it is interesting. You mentioned that Zim has 8 legal bases. What are the two that beyond the GDPR, if you are able to share before we split?
No, obviously the scientific research and where the information has already been made public, you can process it because it's already in the public domain. You don't necessarily need to seek consent, or you don't need to have another legal basis for that.
Oh, okay. All right, all right. But even if it's public, you do still need to follow the standard principles, right?
Yes, you still need to, but you can therefore say that, 'cause just like with any other lawful basis, you still need to follow the standard principles. But then, where someone's made the information public, for example, remember all the maybe I'll put it this way: the most appropriate legal basis, but the least applicable is consent. I hope you get that statement. Most appropriate, but
Yes.
the least
Yes.
applicable. So the issue there is that mostly outrightly, whenever you want to process someone's information, you must seek their consent, isn't it? But because it's the least applicable, that's why we have to go and look elsewhere for other applicable legal basis. So you look for your legal obligation, contractual obligation. But now, when someone posts, for example, on LinkedIn that they're looking for a job and then they post their CV, it means that anyone who wants can just send them job advertisements to their email, and you are unable to ask the person, where did you get my email address? Because you just, I got it from LinkedIn. Or you said to the person, why are you sending me this job advertisement? I don't need to receive it from you. You understand where I'm coming from? So then
Yes.
that becomes a lawful base. So you're still required to comply with the other principles, the lawfulness, the purpose limitation. So in that regard, you may then process the email address for the purpose of having someone get job advertisements, because they went outright and gave out their email address on a public platform that they're looking for a job or they're unemployed, and then you can use that information. You are unable, however, to go beyond the purpose, because depending on the context. But there's an interesting European Court of Justice case. I don't know, I haven't been following it, so I'm not really sure where it is, about the AG Rantos case, about where someone has been receiving advertisement from Meta about I think related to the LGBTI or something like that. So I'm not really, I can't remember all the facts of the case, but I think if you've got the manual to the training, in that case we did cite
Yes.
it very, yeah, in that case. And I think the Austrian court in that instance did not really agree with the fact that when something information is public, it's an outright consent for you to process it according to what they've said, unless if there is reasonable belief that this information is directed to a certain category or certain audience. So if you're not part of that audience, then you may not then take advantage of process that information. So it is an interesting one that we have in our law. And the way that our law puts it, it's making it as an exception to consent. So which means that it's a standalone lawful basis that you may rely on if you want to process someone's personal information.
Oh, that's actually interesting to know.
Yeah, yeah.
All right. Thank you, Advocate, and thank you, Justice, for the that presentation. We will be resuming next week. We'll be going to Chapter 6. I'll be getting in touch with the people who will be handling Chapter 6. And Chapter 6 is going to be on data subject rights, which is an interesting area because that was one of the research areas when we first started the policy and practice group. So we'll be looking into that. So join us next week. We'll be having the policy and practice working group looking at data subject rights. I'll share at a later date the people who will be doing the presentations. And until then, thank you from me, and thank you to our presenters, Advocate Manenji and Justice, for their presentation. Unfortunate that Advocate had issues with the network, but he still did manage to put in some time. Thank you for everything, and goodbye.
Okay. Thank you too. Mhm.
All right.